In this lecture, we're going to discuss criminal prosecutions, in particular, the criminal trial process. In particular, in this module, we're focusing on the steps that are involved in the processing of an accused offender through the criminal justice system. So we're going to focus on the pretrial steps that are involved. We're going to look at a criminal trial procedure, i.e. the criminal prosecution of a defendant. We'll look at all the actors that are involved in this process, so everyone from the police officer to the defendant, the prosecutor, criminal trial lawyer, judge, jury, etc. And finally, we'll also look at the legal rights of the defendant as codified in the Canadian Charter of Rights and Freedoms that is paramount throughout this whole process. So before we talk about process, we're going to talk about some of the key actors in the criminal trial process. We won't so much focus on the police because we've already talked about them in previous modules, but we will focus on the defendant, the defense lawyer, the Crown prosecutor, the judge, the jury, all of those who are involved in the actual trial process after the police have executed their law enforcement duties. So we shall begin our examination of the various actors involved in the criminal justice system by focusing on the defendant and some salient issues regarding the defendant or the accused in the context of criminal trial. First of all is that they can enter a plea during the pretrial process, and this is often done during the arraignment hearing. The defendant can choose a lawyer or can have one assigned by the court, a legal aid lawyer. For indictable offenses, a defendant can elect to have a preliminary trial held, and the preliminary trial is basically to determine whether or not there's sufficient evidence to move ahead with a trial. A defendant can also choose to have a trial by either judge or jury. And again, this is only for indictable offenses, not summary offenses. The defendant can be released before a trial on bail, and this would entail a bail hearing, which we'll talk about in a bit. And probably most importantly when we're talking about the defendant is that their rights are protected by the Charter of Rights and Freedoms. So throughout every stage of the criminal justice process, from arrest all the way to sentencing, the defendant's rights are protected by the Charter. And we've discussed in previous modules the various rights that the accused have in the context of a criminal trial process. And one of these rights is that the accused does not have to take the stand. And this is a particularly important right and important point to be made in a criminal trial process. And this is really part of a broader right, which is that the defendant is presumed innocent and not guilty, and so that the onus of proof is on the Crown to prove guilt. It's not the onus of the defendant to prove their innocence. And so part of this is that they do not have to take the stand because they also have the right not to incriminate themselves, not to say anything that may be held against them within the court, within the criminal trial procedure. So the defendant has the right to represent himself. He also has a right to the services of a lawyer in a criminal trial. If the defendant does choose to use a lawyer, he or she may retain a lawyer in private practice and pay the cost him or herself, or the defendant may resort to legal aid. And if legal aid is requested, a number of criteria will be applied to determine the eligibility of the accused for legal aid services, such as his income and the merits of the case. In the fiscal year 2007-2008, Canadians made a total of more than 300,000 requests for legal aid in criminal cases, and the vast majority of those were approved. So some of the functions that a defense lawyer plays with respect to their client, they are to represent the interests of the client at all stages of the criminal trial process, from bail hearing, preliminary trial, all the way through to the actual criminal trial and the sentencing hearing. The lawyer is involved in preparing the case, determining the strategy to pursue, The defense lawyer is there to help the client understand laws, procedures, and even a possible sentence. They are there to deal with the police and the prosecution, so they're representing the client on behalf of their dealings with the Crown and with the police. They're there to ensure that the police and the prosecution disclose all evidence they've collected. They are also a key player in plea bargains. In other words, they will represent the client as far as bargaining with the Crown as to the actual plea that the accused may make to avoid a trial or in the midst of a trial. The defense lawyer is there to challenge all the evidence presented by the Crown, to question witnesses presented by the Crown, to bring forth witnesses that speak on behalf of the accused, and basically there to counter all the arguments that are being made by the Crown prosecutor. And the defense lawyer is also key in launching an appeal based on the verdict of a trial, and can also be involved in launching a challenge of the verdict based on the Charter of Rights, arguing that the rights of his or her client has been abrogated. The Crown prosecutors or attorneys are the lawyers who represent the Crown or the government in court and are responsible for prosecuting criminal cases. Both the provinces and the federal government engage in prosecutions with provincially appointed Crown attorneys handling criminal code offenses and federally appointed Crown attorneys handling violations of other federal statutes such as the Controlled Drugs and Substances Act. So Crown Counsel are involved in a wide range of activity. They provide advice to police officers at the pre-charge stage. They prepare for trial. For example, they collect evidence from police and other sources. They research case precedents. They interview victims, witnesses, and experts who may be called to testify. They prepare for post-trial appeals if an appeal is launched. The Crown Counsel are also involved in negotiating pleas, developing trial strategies, managing witnesses, arguing conditions at the bail hearings, recommending sentences to the courts, and appealing sentences that they may deem to be too lenient. Crown attorneys also have to keep up to date on changes in the law and in judicial precedents, including decisions in charter cases. The important thing to keep in mind about a Crown prosecutor is that their job is not necessarily to convict the defendant. Their job is to enforce the law and to ensure justice is served. And sometimes this may not be the case, and certainly with some Crown prosecutors, they may see their job as one is to convict. And it's often argued that a conviction looks much more favorably upon a Crown prosecutor than an acquittal. But technically and theoretically, the Crown is there to ensure justice is served and to enforce the law. So they decide whether or not a case goes ahead. And this is a particularly important aspect of the Crown prosecutor because, again, this indicates the amount of discretion they have in the criminal process and criminal trial process in particular. So, as we've discussed earlier, all actors in the criminal trial process or in the criminal justice system have a lot of discretion as to their decisions they make, and the Crown prosecutor is no different. So their discretion is exercised in the context of whether or not to prosecute a case or prosecute the charges that are brought forth by police. So they don't really have much say during the investigative stage, and this is in contrast to the United States, where district attorneys and assistants will actually be involved in the investigation. In Canada, the Crown and Crown prosecutors don't play an active role in the investigation conducted by police. They may offer some advice, but they don't have any say in whether or not charges could be laid. Their role in determining whether a case goes ahead is basically at the stage where police lay the charge and the case is turned over to the Crown, and the Crown's job is basically to determine whether or not to move ahead with that case. In other words, whether there is sufficient evidence to convict. So the Crown is absolutely key in ensuring that all evidence is disclosed to the defendants. They will make opening statements to the jury. They will lay out the evidence and examine witnesses in preliminary hearings. And another important thing to keep in mind about Crown prosecutors is that they have exceptionally heavy workloads. They will handle a myriad of cases at any one time, and in any one day, they could be juggling 6 to 10 cases. Finally, it's important to note, in addition to the discretion that a Crown prosecutor exercises, there's a tremendous amount of burden on the Crown prosecutor in a criminal trial, because it's up to the Crown to prove the guilt of the defendant beyond a reasonable doubt. And so not only is the burden of proof on the Crown prosecutor to prove guilt, but that guilt must be proved beyond a reasonable doubt. And so there's tremendous amount of pressure on the Crown because of these aspects of the criminal justice system. So I just want to spend a little more time on this whole idea of prosecutor discretion. And again, it emphasizes the critical role that the Crown prosecutor plays in determining whether or not a case goes ahead, not to mention a number of other aspects of the case. So again, this is a reflection of the tremendous amount of discretion that's given to actors in the criminal justice system. So in addition to deciding whether or not a criminal case is to be actually prosecuted, the prosecutor decides whether or not to drop the charges or to go ahead with the charge. They determine whether or not to plea bargain with defense counsel. Police generally don't have a big say in that. They determine whether or not a charge should be prosecuted as an indictment or a summary charge, and this is particularly true in those hybrid offenses like sexual assault. And they also will have a say on whether or not the proceedings should be stayed, in other words, should be stopped. So there's a number of factors that the Crown prosecutor has to weigh in making a decision. Is there sufficient evidence to convict? What is the actual offense? If it's a summary offense, it may not warrant going to court. They may want a plea bargain. Does the offender have a long criminal record or any record at all? That will determine whether or not to go to trial or plea bargain. Does the Crown prosecutor have witnesses? Are there victims that will testify on their behalf? So a lot of the factors really revolve around whether or not the Crown can actually win the case, whether there's sufficient evidence to move forward with the case, and to determine whether or not the criminal justice system and society as a whole will be better served by a trial, by a plea bargain, or by staying the charges. So once again, the Crown prosecutor has a tremendous amount of discretion as to whether to proceed with a particular charge, to prosecute their charge, or how that charge should be actually dealt with through a trial or plea bargain, etc., etc. Finally, we're going to talk about the trial judge, obviously a very important player in the criminal trial process. A judge actually plays two roles. The judge is a referee, basically presides over the trial to ensure that the trial runs smoothly, that the rights of the defendant are respected, that all the procedures are followed. And the trial judge is also the judge and the jury in cases that don't involve a jury. So they make an actual decision as to the guilt or innocence of the defendant. They basically determine the verdict. So in a summary trial, so a criminal trial that involves a summary offense, when only the trial judge is involved, where there's no jury, the judge plays the role of both the referee and makes a decision of the verdict, guilt or innocence. And in a jury trial, the judge is the primary role of a judge is to be a referee. So in general, the role of a judge in a criminal trial is to preside over or referee the trial. They will determine guilt or innocence. If there's no jury, they will admit and exclude evidence. They will instruct the jury if a jury is involved in an indictable offense regarding evidence and charges. And they will also make sure that, again, all the procedures are being followed appropriately. They, of course, as you see in the criminal trial TV shows, they will determine whether a prosecutor or the defense counsel stays within the boundaries of a criminal trial. The one last thing to note about trial judges is that they are appointed by government. They don't run for election as in the United States. So all judges are appointed in Canada, whether it's a criminal court or otherwise. The federal government appoints Superior Court judges and higher. So these are judges that sit within a provincial Superior Court or Supreme Court and higher, including Supreme Court of Canada. And it's up to the provincial court to appoint judges at lower levels. So they will appoint judges for provincial courts. So now that we've talked about the role of the different actors in the criminal justice system and the criminal trial process in particular, we're going to turn our attention to the actual steps involved in a criminal trial. And more precisely, we're going to look at all the steps involved in the pre-trial and criminal trial stages. And we'll talk about sentencing in the next module. So to provide a broad overview of a criminal trial process, the first thing to keep in mind is that the trial is based on an adversarial approach. And the adversaries are the defendant on the one hand and the state on the other. The advocates for each party in criminal cases, the defense lawyer and prosecutor, present their cases before a neutral judge or jury. And this system is in contrast to other innovations in the criminal justice system, in particular restorative justice, which is not an adversarial approach, does not assume an adversarial approach. It actually assumes an approach where the victim and the offender try to work out the aftermath of a case of a particular crime. But this again is quite different from the traditional criminal trial process, which is very much adversarial. Some of the other important aspects of a criminal trial process, again, the proof that law enforcement officials have to charge a defendant is probable cause. So in other words, police have laid a charge based on their suspicion that the defendant has committed a crime. But once the criminal trial procedure begins, the proof to convict is much heavier, as we've talked about, and it's beyond a reasonable doubt. So once again, the judge and the jury cannot have any reasonable doubt that the defendant is innocent. As we talked about, the burden of proof is on the Crown, so the Crown must prove guilt. The defendant does not have to prove their innocence. And all the procedures involved in a criminal trial process are governed by law, are governed by tradition, and also governed by judicial authority, in other words, the judge. So the basic premise of this adversarial system is that ultimately the truth will emerge from the materials presented by the defense and the Crown. And again, the adversarial system is one that obviously engenders great conflict within the trial process, and this conflict has to be managed, and in particular the rights of the defendant have to be managed within this context of the adversarial system. So certainly paramount among the whole criminal trial process is the protection of the rights of the defendant, and that's why the Canadian criminal justice system is considered to be very much characterized by the principle of justice. So the flowchart on this slide tries to graphically depict the stages involved in the criminal trial process. And it's a very broad overview. What needs to be kept in mind is that there's a number of different options at every stage of the criminal trial process. And this basically depicts what's typical of the criminal trial process. So a charge is laid by a police officer, and then the defendant makes a first appearance, and they can be detained before their trial, or they can be released after first appearance. A trial is commenced, and again the accused can choose whether to go to a preliminary inquiry before they go to trial. And of course the trial is the focal point of the criminal justice process, and the accused is rendered a verdict, guilty or innocent, and if it's innocent, there's no follow-up to the trial unless the case is appealed by the Crown. and if found guilty, the accused can either be incarcerated, provided with probation as a sentence, or can be provided with any range of sentences, which we'll talk about in the next module. But the important thing to remember here is that there's various options at each stage of the criminal trial process, and this graphic lays out some of these options, but does not get into how complicated the process can actually be given the various options at the disposal of the defendant, his or her counsel, and the Crown prosecutor. So before we get into the actual criminal trial process, we'll talk a bit about some of the steps involved in the pre-trial stage. It is essentially a criminal charge laid by a police officer that sets in motion the process that may lead to a criminal court proceeding. Usually a police officer will lay out what's called an information, charging an individual with the commission of a crime. In some circumstances, other enforcement authorities may also lay an information. The charge may or may not involve the arrest of the defendant. If warranted in the circumstances, a police officer may issue the accused a summons to appear in court to answer a charge, in which case no arrest is made. When an arrest is made, the police must first inform the detainee of his right to speak to a lawyer and must do their utmost to have the detainee brought before a judge or justice of the peace as soon as possible for a bail hearing. So this hearing will determine whether or not the accused will be held in detention until his or her first court appearance. Now, once the police have laid information against an individual, the Crown takes over the case and decides whether or not there are grounds to prosecute. If there are, the Crown must generally decide whether to proceed by a summary conviction or by an indictment. So in summary, the pretrial procedures are basically an arrest of the defendants. A charge is laid. An arrest may not take place. Again, a defendant or the accused may simply be issued a summons to appear before a court. So just because a charge has been laid doesn't necessarily mean a defendant or accused is taken into custody and arrested by police. So the police have discretion as to whether or not to arrest a defendant, to issue a summons to appear, whether to fingerprint, whether to lock up, whether to release on appearance notice. But once the police have laid a charge, then the whole criminal trial and pretrial procedures begin. And at the stage that the charge is laid, the case is basically handed over to a Crown prosecutor to proceed with. The next step in the pretrial process is arraignment. The arraignment of the accused takes place very early in the criminal justice process, and it may in fact be the first appearance by the accused before the court. So it may in fact take place before a bail hearing. The arraignment is basically the venue where the charges are read in open court and the accused enters a plea. Now, of course, the most common pleas are guilty and not guilty. If a plea of guilty is entered, then the case goes directly to sentencing, so there is no criminal trial. If a plea of not guilty is entered, then the case is bound over for trial. The steps to begin a criminal trial are undertaken. And again, remember that in this adversarial system of justice, all accused are presumed innocent, and therefore the onus is on the Crown to prove guilt. So again, the arraignment can be very quick. Basically, the charges are read to the defendant. The initial plea is made. In Canada, the vast majority of pleas in the arraignment are actually guilty, and so it proceeds directly to sentencing. And in the case of a not guilty plea, the date for the trial or the bail hearing may be set. And some offenses may actually be tried immediately. This is particularly true if it's a summary offense. So the next stage in the pretrial process is the bail hearing, otherwise known as the show cause hearing. Now, this only takes place if the offender or the accused has been arrested and detained and placed in the police lockup by law enforcement authorities. So the whole purpose behind the bail hearing is to determine whether or not the accused can be released on his or her own recognizance before his or her trial commences. So a judicial interim release or bail is overseen by a judicial functionary, usually a justice of the peace, but also a superior court judge if the offense is a serious one, such as murder. A person in police custody not released by the officer must be brought before the court within 24 hours after a charge has been laid or after arrested, or as soon as reasonably possible. And again, this is a fundamental right guaranteed to defendants, the accused, under the charter. They have to be brought before a judicial official 24 hours or as soon as possible after the arrest or a charge has been laid. The justice of the peace or the judge has to determine in a show cause or bail hearing whether the accused will be released or will remain in custody until the case is disposed of through a criminal trial. So Section 11 of the Charter of Rights and Freedoms stipulates that any person charged with an offense has the right not to be denied bail without reasonable cause. If the Crown chooses to oppose the release of the accused, the Crown must demonstrate at a bail hearing that the detention of the accused until the trial date is necessary for the safety and security of the public. So in support of the recommendation that the accused be held in custody, the Crown can produce evidence of prior criminal convictions, other charges currently before the courts, or previous incidences of failing to appear in the court. In other words, bail is often denied if the defendant is shown to be a chronic offender, violent, may cause further harm to the security or safety of the public, or may be a flight risk. In other words, may not actually show up for a criminal trial. So again, the onus of proof is on the Crown to show that the defendant is dangerous or is a flight risk. In other words, they must argue why the courts should deny bail to the defendant. Now, in some cases, the reverse onus is applied. In other words, the accused has to show cause why a release is justified. So these situations include ones in which the alleged indictable offense occurred while the person was on bail for another charge. A detained person seeking pretrial release are often required to make multiple appearances in court before a ruling is made, mostly due to overcrowded court dockets and a lack of personnel to participate in bail hearings. So if the JP, the Justice of the Peace, or a judge decides to release the accused, the conditions under which the release will take place must be determined. So again, the Crown must show cause why the conditions should be attached to the release. And the accused person must be required to relinquish, or often they have to be required to relinquish their passport. They have to report periodically to the police. They have to avoid contact with the complainant or other witnesses or other criminal colleagues. They're often restricted from possessing firearms. This is actually usually a mandatory requirement. And young offenders released on bail may be required to live with a parent or another responsible person to guarantee that they will appear in court. An accused person may also be asked to enter into recognizance in which they agree to forfeit a set amount of money if they fail to appear in court. Now, if bail is not granted, that basically means that the accused is committed to a center or a provincial lockup until his or her trial has commenced. Now, another step that typically follows the arraignment and or a bail hearing is what's called a preliminary hearing. And this is only for accused who have been charged with a serious indictable offense. And it's also only proceeds if a not guilty plea has been entered. Obviously, if a guilty plea has been entered, then the case goes directly to sentencing. But if a not guilty plea has been entered in a case involving an indictable offense, the accused has the option of choosing whether or not a preliminary hearing can be held. And basically what a preliminary hearing does is for a judge to determine whether or not there is sufficient evidence to proceed with a criminal trial. And the defendant may waive a preliminary hearing. But in general, it serves their purpose to actually have a preliminary hearing because there is the likely circumstance, or there is some circumstance, that the case could be thrown out because there's not sufficient evidence to proceed with a trial as determined by a judge. If the judge decides that there is insufficient evidence to proceed with a trial, then the case can be actually thrown out. The charges are stayed, which means there's basically no trial. The defendant no longer is under these charges. Doesn't necessarily mean the case is closed. It simply means that the police may have to go back and gather evidence, and they can lay a charge again. Now, the judge decides if there's enough evidence to proceed, and if the judge determines that there is sufficient evidence, then the accused is committed to stand trial. And if the judge determines there's not enough evidence, then the accused is set free. But again, as I mentioned, this does not preclude the police from gathering more evidence and laying a charge again. At this stage, I want to talk a bit about plea bargains. A plea bargain can take place at any stage during the pretrial or criminal trial process. I talk about it here because most pleas are bargained before a case goes to trial. So, what is a plea bargain? A plea bargain is basically a negotiation between the defendant and the Crown where the accused gives up the right to make the Crown prove the case at trial in exchange for the promise of some kind of benefit. In other words, the defendant and the Crown negotiates to avoid a trial, and the accused basically agrees to plead guilty, while the Crown promises the accused certain benefits or certain rewards if the accused pleads guilty. So in other words, some typical plea bargains is that the Crown will agree to proceed on a lesser charge. They'll drop some charges. They may make the argument to a sentencing judge that he or she should impose a lenient sentence. The Crown may proceed with a summary charge instead of the indictable charge. So it's basically a bargain. On the one hand, the accused pleads guilty to one or more charges, and in return, the Crown agrees to reward the accused for agreeing to plead guilty. And there's actually a lot of pressure on both the defendant and the Crown to plea bargain. There's particularly a lot of pressure on the Crown to plea bargain because criminal trials are very resource intensive, and the Crown at both the provincial and federal level often have very limited resources to prosecute criminal cases. And if you can avoid a criminal trial, then that means the Crown does not have to expend those resources. So there's often much more pressure on the Crown to plea bargain a case than the accused. But obviously, if it seems to be an open and shut case against the accused, if there's a predominance of evidence against them, certainly it works in their advantage sometimes to plea bargain a case, especially if that means they're going to get a more lenient sentence. Now, if a criminal trial actually does proceed, in other words, there is sufficient evidence to prosecute the accused and no plea bargain has been struck, another important pretrial procedure is the selection of a jury. And again, juries are only used in Canada for indictable offenses, and it's up to the accused to choose whether he or she wants to be tried via jury or via a judge alone. Jury trials are actually quite rare in Canada. Most criminal charges are summary charges, summary offenses, so there is no jury, it's judge only. And in many of the indictable cases, the accused often choose to have a judge-only trial. But if a jury is opted as the choice of the defendant, the first step is to actually select a jury. And that is done generally through a list of eligible jurors, which is generally taken from a voters list. Every province and territory has legislation that sets out the qualifications for jurors, and also provides other directives for selecting juries and guiding their activities. So jury duty is still regarded as a civic duty, with only few exceptions. A person called for jury duty will be required to serve. In other words, it's often very difficult to get out of jury duty. The responsibility for setting the qualifications for jurors, as I mentioned, falls under provincial jurisdictions. Jurors who are qualified to serve are usually between the ages of 18 and 65. They don't have a criminal record or any physical or mental impairment. Potential jurors, as I mentioned, are identified from tax assessment lists or voter lists. In the context of criminal trials, it's a minimum of 12 jurors who sit in a jury. The exception is in the Yukon Northwest Territories and Nunavut, where juries are composed of only 6 people. But again, in the vast majority of criminal trials throughout the provincial jurisdictions, each jury is made up of 12 people. Juries are finders of fact, and so while the role of the judge is to interpret the law and instruct the jurors, it's the jury that will determine the guilt or the innocence of the accused person. And of course, as we know, jury decisions must be unanimous, and again, there cannot be any reasonable doubt in the minds of jurors. So as you can see, it's a fairly onerous burden of proof for the Crown and for the jurors. So again, to repeat, a jury must be unanimous in its decision on guilt or innocence of the accused, and that unanimous decision must be beyond a reasonable doubt. In other words, no one jury has any reasonable doubt that the accused is innocent. So if they're going to render a guilty verdict, the jury must be unanimous, and their guilty verdict must be based on beyond a reasonable doubt. One last issue I'd like to talk about before we get into the criminal trial is the issue of disclosure. Basically what this means is that the Crown must give defense lawyers access to all evidence that may be presented by the prosecution in a trial, especially if that evidence may indicate that the accused did not commit a crime. So this process is called disclosure of evidence or discovery. And the failure to disclose evidence by the Crown and by police can actually trigger a charter challenge, because it basically impairs the ability of the accused to be knowledgeable about all evidence being presented within a trial. So disclosure is a basic fundamental right of the accused, and it was actually a Supreme Court decision. So it was the Supreme Court that ruled that the police and the Crown must make available all evidence for use by the defendant in the context of a criminal trial. So obviously all this evidence has to be disclosed before the trial proceeds, because the evidence is crucial to the strategy that a defense counsel will pursue with respect to their defendant, their client in this case. So now that we've talked about the actors involved in a criminal trial and all the pre-trial stages, we'll now turn our attention to the criminal trial itself. Again, to reiterate, the whole basis of the criminal trial is this adversarial system, with the belief that through this adversarial approach, the truth will emerge and justice will be served. A trial takes place if the accused person who pleads not guilty does not change that plea, and the Crown does not withdraw the charges or terminates the matter with a stay of proceedings. And again, the Crown has the discretion to stay the proceedings, which basically means that the Crown withdraws the charges and no criminal trial goes ahead. But if a trial does go ahead and all the preliminary steps have been satisfied, then a court date will be set, and all these steps will be undertaken to ensure the trial goes ahead, which may include selecting a jury, selecting the courthouse, and any other circumstances that must be taken care of to ensure that the trial is carried out in an effective, efficient, and just manner. Now, as we've discussed previously, a trial is actually quite rare. It only occurs in about 10% of criminal cases. The majority of cases are resolved via plea bargaining or by the Crown Counsel staying the proceedings or withdrawing the charges. A criminal trial is often too complex or too complicated to summarize in a couple of minutes, let alone through a few PowerPoint slides. The important point, or certainly one of the most important points, again, is that the burden of proof is on the Crown, and they basically have to show the judge or the jury that the accused is guilty of the offenses, and they have to basically prove the two basic principles of a crime, and that is mens rea and actus rea. So that the mens rea is that the accused had intent to commit a crime and actually carried out that crime. So a trial will usually begin with opening statements. So the prosecution will outline evidence, will identify witnesses. They, again, as I mentioned, have to prove beyond a reasonable doubt. And one thing that should be noted in a criminal trial is that the prosecution cannot focus on the accused prior record. So if the accused has a criminal record, the prosecution cannot really focus on that. And again, the reason is that this is a trial about a particular charge, a particular offense, or the accused committing a particular offense. It's not about the accused's past. Now, an accused prior record is very salient when it comes to their sentencing, because that's one of the factors that's taken into consideration. But in general, the prosecution cannot dwell on the accused's prior record, and again, it's often a matter of contention whether or not the prosecution can bring it up. Usually a judge will rule in favor of the prosecution discussing the prior record if it's salient to the offense being prosecuted in the trial. So in other words, if it's a sexual assault charge, if the accused has a history of sexual assault and convictions, then that can be deemed relevant. The defense counsel has the option of making an opening statement. In that circumstance, they will outline their case, and their basic role of the defense counsel is to undermine the case of the prosecution. So it's very much literally a defensive position, is that you're not out to prove the innocence of the accused. You're out to basically argue against the finding of guilt by the prosecution. The case of the defense is to undermine the arguments of the prosecution. In other words, it's to inject the reasonable doubt in the minds of the judge or the jury. So I'm not going to get into the intricacies of a criminal trial. It's too complex, too complicated, but I will talk briefly about the foundation of a criminal trial, and in particular whether or not a accused is proven guilty or innocent, and everything revolves around evidence. The whole trial, the verdict, is very much contingent upon evidence that's presented in the trial. So everything revolves around evidence, and obviously the verdict is very much premised on the evidence that's presented in a trial, and in particular, evidence has to be factual evidence. And this evidence is either a testimony provided by eyewitnesses, by police, or by experts who may, for example, argue that the fingerprints on a gun belongs to the accused. But what's most important is that this evidence is factually based, or based on at least scientific evidence. So in addition to testimony, other kinds of evidence is what's called real evidence, which includes the discovery of weapons or the fingerprints at the scene of a crime, It includes perhaps surveillance video. Direct evidence is eyewitness observations, and eyewitness observations are often very crucial in criminal trials. What the court really tries to avoid is circumstantial evidence, although it can be permitted, but circumstantial evidence is not factually based. It's basically inferential. In other words, you can imply based on evidence that the accused is guilty or not guilty, as opposed to making a more conclusive determination based on hard or real evidence. And certainly what's not permitted in a trial is what's called hearsay evidence. And hearsay evidence, for example, is where someone takes the stand and says that they heard from a friend that the accused committed the crime. That's not permitted. Only direct eyewitness evidence would be permitted in such circumstances. What's interesting currently is what's being called the CSI effect, and that is jurors and others are expecting that police will come forward with absolutely conclusive scientific forensic evidence and therefore make their job much easier in determining a guilt or innocence verdict. But that really is very rare in criminal cases. There certainly are open and shut cases, but much of the evidence presented is far more nuanced. It's far more complicated and often relatively easy for the Crown to present, but also easy for the defense counsel to refute or counter. So criminal trials are very complex. The presentation of forensic scientific evidence certainly doesn't assume the predominant role in real-life criminal trials than it does in the TV criminal trials. But again, the important point of any criminal trial is that it lives and dies by the factual evidence being presented by the Crown and the ability of defense counsel to refute that evidence either by undermining its veracity or presenting evidence that contradicts it, such as eyewitnesses who may contradict the testimony of other eyewitnesses. Now, after all the evidence has been presented in a trial, the trial concludes with the closing arguments. There's a closing argument made by the defense counsel and a closing argument made by the Crown prosecutor. And the order of the closing arguments generally depend on whether or not the defense has used witnesses or has introduced evidence in a criminal trial. What's important about the closing arguments is that the Crown and the defense may make inferences about the evidence presented. So in other words, they draw their conclusion on the evidence presented, and these conclusions may be factually based, and again, they may be subjective opinions based on inferences drawn from the evidence. And again, the point here is that the defense and the Crown are trying to prove their case. So their closing arguments are very much about taking all the evidence, collating it, and then drawing inferences on whether or not the accused is innocent in the case of the defense counsel or guilty in the case of the Crown prosecutor. What's also important at this point to mention is that during the closing arguments, neither the Crown nor the defense counsel can introduce any new evidence. So they can only draw conclusions based on the evidence that's already been presented in the trial. So once the closing arguments are made, if it's a jury trial, the judge will then undertake what's called the charge to the jury, and that is basically instruct the jury as to how they are to go about determining the verdict of the accused. And so in many circumstances, the judge will outline the principles of law. They may define the offenses that the accused has been charged with. They will discuss the requirements of how the jury must consider the evidence. And most importantly, they will emphasize that First of all, the jury has to be unanimous, and secondly, they will emphasize that the verdict or the decision has to be beyond a reasonable doubt. So again, none of the jurors can have any reasonable doubts that the accused is innocent. In other words, if the jury finds that the defendant is guilty, it has to be beyond a reasonable doubt and it has to be unanimous. Now, a judge may also inform the jury of the possible verdicts that they can deliver. And often it's simply between guilty and not guilty, but there may be other nuanced verdicts that can be reached by the jury. But again, the most important role that the judge plays with respect to the jury, again, is providing them the kind of technical support that they will need in trying to reach their verdict, and most importantly, reiterating the fundamental concept in a criminal trial that jurors have to be unanimous, and if they're going to find guilt, it has to be beyond a reasonable doubt. Any reasonable doubt, and that means that the accused goes free. And the last thing to talk about with respect to jury is the whole issue of the so-called hung jury. And basically, a hung jury is a jury that cannot come to a unanimous decision. So there may be 2, 3, or even more members of the 12-person jury who do not agree with the verdict of the others. They may have reasonable doubt. Judges try to do everything possible to guard against a hung jury, to try to ensure unanimity in their decision, but certainly hung juries do happen from time to time in criminal cases. So as far as the verdict is concerned, which concludes the criminal trial, as mentioned, the jury must be unanimous. Any hung jury will result in a mistrial, which means that this particular criminal trial is stopped and a new one may take place, or perhaps a plea bargain to be affected by defense counsel and the Crown. Now, if a guilty verdict is reached, the first thing that we should note is that the trial judge has no role in the actual sentencing of the accused. So once the criminal trial is over, then it's over. The only thing that a trial judge will do is perhaps set a sentencing date. The judge may also order a pre-sentencing report be put together. And while a criminal trial may have ended, this does not mean that the case is over. In other words, appeals may be initiated by the Crown if a verdict of innocence was found, or it could be initiated by the defense counsel if the guilty verdict was delivered. So the next stage, if in fact the trial has ended and a guilty verdict has been rendered, then the next stage in the process is the sentencing trial, which we'll talk about in the next module. But also there may be another trial based on the appeals that's being launched either by the Crown prosecutor or by the defense counsel. Now, as far as an appeal is concerned, if the defendant is convicted, he or she may appeal the verdict or the sentence handed down in a sentencing trial, or may even appeal criminal responsibility. Now, the prosecution can also appeal if the defendant is found innocent, or if the sentence is one that they find to be far too lenient. Now, if the defendant is appealing, or if the Crown is appealing the case, the defendant may actually apply for release while the case is under appeal. And again, it really varies with whether it's a summary charge or an indictable offense. If it's a serious indictable offense like murder, then the chances are that the accused will have to remain in jail while the appeal process moves forward. So if an appeal is launched, it's really up to the provincial appeals court to determine whether or not they will hear that appeal. And if they do agree to appeal that hear that appeal, they can basically determine two things. They can either determine that the decision of the lower court is upheld, or they may in fact refute that verdict and order another trial to be heard. So a case can be overturned on both an acquittal and a conviction. Now, not every case can be appealed. In fact, the majority of cases, an appeal is not filed. The right to appeal exists only in certain situations, and in others, the Court of Appeal can grant leave or permission to appeal. So either the Crown prosecutor or the defense lawyer cannot file appeal, as I said, and a distinction is made between grounds for appeals that involve questions of laws, those that involve questions of fact, and those that may involve both. So basically appeals are launched either on questions of fact. So for example, the defense counsel may argue that the facts presented in a case were really wrong and the decision should not have been based on these erroneous facts. And defense counsel can also appeal, basically arguing that the rights of the defendant were abrogated or that certain procedures within the criminal trial process were not followed properly. For example, the charges that a judge may make to a jury can be appealed because they may seem to be too biased. So once appeal has been launched, as I mentioned, the incarcerated defendant may be released on bail until the appeal is heard. But if it's a serious indictable offense, then often they will stay in jail. And the judge who hears the request for appeal will consider among other things, the merits of the appeal itself. And so this is really to ensure that frivolous appeals are not launched. So finally, when we talk about the Supreme Court is the final appellate court of the country of Canada. It only hears appeals on questions that involve the legal proceedings or questions of law. It does not consider cases based on the facts of the case. So we'll only hear appeals or we'll only hear decisions that revolve around questions of the legal proceedings, whether the law was applied justly and whether the law in fact was just. And so many appeals that go to the Supreme Court revolve around questions that the rights of the accused have been trampled upon and the law itself is unjust and therefore should not have been applied in this case. I'd like to again emphasize the importance of the legal rights of the defendant in the criminal trial. Again, it has to be emphasized that the legal rights of the defendant is paramount in a criminal trial. This is really why the justice principle is considered the dominant principle in the Canadian criminal justice system, because the rights of the defendant is considered so paramount. And again, as we've mentioned, these rights are protected by and enshrined in the Charter of Rights and Freedoms. And as we've discussed earlier in this course, there's probably no institution like the criminal justice system that has been so affected by the Charter of Rights. And in particular, the Charter has granted defendants significant rights within the context of the criminal justice system and within the criminal trial process in particular. So some of the basic legal rights of the defendant in the context of a criminal trial and during the pre-trial and criminal trial stages is first and foremost the presumption of innocence, which is a fundamental presumption of criminal law, which is the defendant is innocent before proven guilty. And as such, as we've discussed, the burden of proof falls on the state, and in the case of Canada, the Crown prosecutor. So the Crown must prove guilt beyond a reasonable doubt that the defendant or the accused is guilty, and the juror is instructed by the judge that their unanimous decision also has to be based on the absolute guilt of the defendant beyond a reasonable doubt in the minds of the jurors. So some of the basic legal rights that are enshrined in the Charter of Rights and that are accorded to the defendant within the context of a criminal trial, including the pretrial and trial stages. The first is the fundamental presumption within criminal law that the defendant is innocent before proven guilty. And as we discuss, what this means is that the burden of proof falls on the state, in the case of Canada, the Crown Prosecutor, to prove guilt. It's not up to the defendant to prove innocence. It's the burden of the state to prove guilt. And in this context, they must prove guilt beyond a reasonable doubt. The defendant also has a right to a jury trial, the right to be tried by one's peers, and specifically the defendant has the right to choose between a judge and a jury trial in the case of indictable offenses. Within Canada, the defendant has the right to confront the accuser within the court of law, and that basically means the defense counsel has the right to cross-examine the accuser, the victim in many cases. The defendant has the right to remain silent, and this carries out through the whole pretrial and criminal trial process. So when arrested, the defendant does not have to say anything to police, and during the course of a trial, the accused does not have to take the stand. And this is a fundamental aspect of the rights of the accused, is they do not have to take the stand and be examined or cross-examined by the Crown. Finally, as we discussed, defendants accused have the right to what's called full disclosure. And this is a decision that was made by the Supreme Court. It wasn't something that was specified in the Charter of Rights, but this was an interpretation of the Charter of Rights by the Supreme Court, and it was based on a particular criminal case called the Stinchcombe case. That was the name of the defendant. And in this case, it was thrown out by the Supreme Court based on the argument that Crown Counsel and the police did not hand over all the evidence to the defense counsel. In particular, evidence was omitted that could have been very useful to the defense counsel in arguing against the guilt of the accused. So this Supreme Court decision basically argues that the defendant has the right to review all evidence gathered by police, and this evidence must be disclosed in a complete and timely manner. And what's particularly important is that the Crown discloses evidence that may be contrary to the case that they are building. In other words, evidence that may actually work in favor of the defendant. But this has a very important decision, and it creates a particular onus on the Crown and on police. And some argue that police will now not even take certain notes during a criminal investigation because of the fear that these notes may be disclosed to defense counsel. So police and the Crown have to walk a fine line between collecting evidence and collating evidence that will work towards a guilty verdict, but at the same time will have to be disclosed to defense counsel, and some of that may in fact be beneficial to the accused. Now I'm going to end this lecture with just some recent statistics on criminal trials in Canada. These have been provided through Statistics Canada. In 2010-2011 fiscal year, nearly 403,000 criminal court cases proceeded, which involved about 1.2 million criminal code charges or offenses under other federal statutes. 64% of all criminal court cases in this period resulted in the finding of guilt. And that basically states that most criminal cases are actually plea bargained before they enter the criminal court stage. So cases that are not plea bargained are ones where the Crown has a very strong case and they're not willing to plea bargain it. And because of that strong case, you're seeing a fairly high success rate in the finding of guilt. 64% is a pretty good success rate for the Crown in findings of guilt. The median length of the adult criminal court case is about 118 days. Most criminal court cases for adults have become more complex in recent years and are taking more time to resolve. And one statistic that goes back to the fiscal year 2003-2004 is that cases involving multiple charges account for 51% of all adult court cases, which is up from 44% a decade earlier. So the more charges that are being prosecuted in a criminal case, the more complex it's going to be and the longer it's going to take. What we've also seen in recent years is the so-called mega trials, and mega trials are ones that typically involve multiple defendants being tried together. And this is often applied in cases that involve organized crime. Again, the very definition of organized crime is that there's multiple people being involved. So there were some very famous cases in Quebec involved that were mega trials that basically involved a number of Hells Angels members as defendants. And of course, mega trials are exceptionally complex and often take a very long time. And in recent years, there's been a strong movement towards trying to plea bargain these cases before they come to trial because of the complexity, not to mention the security issues that revolve around trying, multiple organized criminals or accused organized criminals.